Welcome to Crime in Court. This is the 1996 Menendez brothers trial. We are reading through the transcript. We don't have video. This is the Menendez brothers' second trial for the homicides of their parents, Kitty and Jose. As we know, they were convicted and sentenced to life without the possibility of parole. They now have the possibility of parole because that has been overturned to what is it, like 50 years or whatever it was. So they now have the possibility of parole, which is this at the end of this month. They will be going up against the parole board for their hearings. So that is some exciting news. They also have some movement. I reported lately in the habeas case where the judge noted that the district attorney, Nathan Hockman, he needs to provide reason as to why the brothers' habeas corpus petition shouldn't be granted. And he needs to provide a good reason. Otherwise, it looks like this judge might be leaning towards granting them some kind of relief for their habeas. So that's what's going on with their path to freedom right now. I believe Gavin Newsom has said that he's just going to wait and see what happens. And I think he said he was like taking it off of his desk or something. So I think he's probably pretty aware that, things are progressing for the brothers for a path for freedom, that he doesn't necessarily need to interject at this point. So that's kind of what I'm feeling from Newsom. He's got his own legal issues going on with the fire potential, the LA fires, and he was, I guess, Spencer Pratt from whatever show that was, some uh stupid show on MTV or VH1 back in the day. And his house burned down in the LA fires, and he's the one that like married Heidi Montag or whatever. I don't know. It was like back in the early 2000s. Anyways, you may or may not remember, but he's basically busted wide open this whole scheme that Governor Gavin Newsom may have been embezzling some money that he was raising for the LA fire uh, victims, and it was going more in his pocket. So that there may be some issues going on there. I don't know, but that's being exposed. Anyways, let us get started. So we are on the state's case, part 11. We are moving on to the next witness. So we just completed or ballistics expert, wound ballistics expert, that's a mouthful. Um, sorry, that was Dr. Martin Fackler. He was on the stand for several days, so we went through his testimony, and we just completed that. He just left the stand. Now we have argument from the attorneys, which is going to go on for a little bit. Buckle up. But after that, we will hear from Dr. Cyril Wecht, who is the forensic pathologist. We did not hear from him in either of the trials, we did not hear from him from either side in the first trial, is what I meant to say. There are actually some witnesses that testified for the state in the first trial that are going to be testifying for the defense, and I will point those out as we go along. But anyway, so this witness, Cyril, did not testify prior to this being called to the stand with what we're going to read today. So let's dive in. Please hit the like button, and let's get started. Oh, before we do, I wanted to show you. So here's where we're at regarding the schedule of people. So today we're going to hear a bunch of argument and then hear from Dr. Cyril Wecht. Okay, he's the forensic pathologist. We did not hear from him in the first trial. After that, they're going to break, and there's going to be a lot of argument about Cyril Wecht's testimony. So we're going to have probably multiple parts of argument because it goes on for quite a while. And then once they come back, we're going to have Dwight Van Horn, who was the deputy with the LA County Sheriff's Department, and he testified for the prosecution. This time he's testifying for the defense. So this is one of those that flipped. Okay. Then we have this is I'm just telling you for the week 8 of this trial who we have on board. So Ron Linhart, we've been hearing their names, Dwight Van Horn and Ron Linhart. He's a crime lab specialist, I guess, with the LA County Sheriff's Department, and he did not testify previously. Then we have a Charles Morton. We've heard his name come up in testimony. He's a private criminalist and a forensic scientist, and he also did not testify in the last trial. And then we'll have some more jury, some more argument with no jury in the room. And then after all of that, we are on week 9, we will get back to Cyril Wecht's testimony. So he's going to start today and then he's going to break and we're going to get back to him days later, just so you know. I just wanted to clear that up so you had an idea of how scheduling's going because they have to, as a trial attorney, you have to balance that and figure out when people are available. This is the week after Thanksgiving. Now we're coming back to trial, and people are, their schedules are busy. It's the holidays, so she's juggling people around their schedules and the court's time and all of it. So just not just she. Sorry, I shouldn't say she. It's not all Leslie Abramson, but it's, as you can see, all of the attorneys down below. For the state, we have David Kahn, Carol Nahara. For Lyle, we have Charles Gessler, Terry Towery. For Erik, we have Barry Levin and Leslie Abramson. Leslie also represented Erik in the first trial. She's the only one that came back in the second trial. Okay, let's get started. One more quick announcement before I forget. I sincerely and profoundly apologize for missing the entire week last week. I just wanted to, well, I want to say I apologize. I don't like to miss days. Honestly, I do not like to miss days. Um, I had a horrible migraine. It was not only affecting my head, but just like balance issues. Being able to read was causing me dizziness, and it was awful. Let's just say it was a week. So I apologize, and I'm feeling much better, and I'm ready to get rolling. I didn't want to start videos at the end of the week, so I just decided to take the whole week off just to let you know, and wanted to catch up, or not even catch up, but like get ahead of it and make a few videos ahead of time. So apologies for missing, but I wanted to take the time that I did have once I started feeling better to start pre-recording more of them, to have more of them, in reserve so I can start scheduling them in advance, hopefully, and we can get these if I do miss a day or two, it's not going to be so drastic because I'll have some saved up. So that's what I'm hoping for with that time, extra time that I took. So apologies. And with that, I will stop with my announcements. All right. So the court says we're back in session. This is their after their afternoon break, coming back in. Mr. Khan says, yes, we've reviewed the 3 pages of what counsel has called notes. I apologize if you can hear that. We've got recycling guys going by right now. It's very loud. Yes, we reviewed the 3 pages of what counsel has called notes. Has called notes. Like, that's so condescending. Like, they're not notes. Counsel called them notes, but they're not notes. It appears to be a typewritten evaluation criticizing the reconstruction that was conducted by Dr. McCarthy in this case, and it's my understanding that this 3-page document relates to something prepared by by Mr. Morton. I think he's a doctor. I don't know, maybe not. I think the first issue. No, he wasn't. Sorry. I think the first issue that we'll need to discuss with the court is whether the defense will be able to present cumulative testimony criticizing the reconstruction of Dr. McCarthy. We've already taken testimony from a wound ballistics expert and spent a couple of days, several days, examining this witness concerning his criticisms of the reconstruction. And now I think that what counsel's proposing to do is getting into a series of witnesses who are going to simply make the same arguments over and over and over again. So I don't think they should be permitted to do so simply because one calls himself a criminalist and another one likes the title of wounds ballistics expert. I think at a certain point, what each person would designate would get into himself. We get into the issue of cumulative testimony. The court says, "All right." Ms. Amerson says, "I didn't think we were here for that point, Your Honor." The court says, "Well, number one, the report that you have now is that." Let me ask the defense. The report that has been turned over to the prosecution, is that a report reflective of the proposed testimony of this witness? In part. Well, what does that mean? Sabins says that means that reflects not all of his testimony is going to be criticism of, not all of his criticism, or sorry, she changed his direction with what she was saying. She says, not all of his testimony is going to be criticism of failure analysis. In fact, I don't expect his testimony will be framed in those terms. His testimony, because he is a blood spatter expert, which none of the previous witnesses have been, and all of the previous witnesses, both defense and prosecution, have acknowledged they're not blood spatter experts. His testimony will have to do with blood spatter patterns and pure ballistics and criminalists in order to explain certain shots, certain wounds that were inflicted upon the victims in this case. In his expertise being different than Dr. Fackler, he has a right to testify about blood spatter. The court says, I'm not asking whether he has a right or not. I'm just asking whether or not that report was reflective of all of his testimony. Miss Abramson says, "Well, I'm not. That's why I asked him if he had anything supplemental. I'd have to look at it again to see if it's everything. I think it covers all of the topics he's going to testify about." Court says, "As far as the objection on grounds of being cumulative, it's premature at this point to address that. From the brief comments of counsel, it does appear that the witness's testimony would be on subjects other than those directly touched upon by Dr. Fackler, so it would not be cumulative." Ms. Abramson says he's not going to offer medical opinions, Your Honor, to any extent that his conclusions on criminalistics and blood patterns have to do with medical opinions. He's obviously going to be relying on the testimony of the medical experts. The judge says, as I said, I'm not now concerned with the objection of it being cumulative. I'm just concerned about discovery. Ms. Abramson says, I just want to quickly review if it has everything that I'm aware of that he's going to talk about. You can wait, and I can tell you. I can answer the question if you can be still. Mr. Khan says, I just want to clarify for the record that we're what we have in our hands. What we have in our hands is simply nothing more than a reconstruction of the shooting, and Miss Abramson says it's a criticism of the reconstruction. It isn't a reconstruction. Mr. Khan says, criticism of a reconstruction, we have no discovery whatsoever concerning anything about the blood, the proposed blood spatter testimony expert of this witness. I would ask, first of all, that we be given discovery in regard to that area of that testimony, if indeed that is going to be the area of testimony, and that testimony, and that this testimony, this proposed testimony of what we have, a summary in our hands, not be presented as cumulative. Ms. Abramson says, I think it's very obvious if counsel just read it that you'll see the word blood appears. Let's see. 1, 2. The court says, I don't want you to count. I don't want a count of that. I want to know whether or not the report reflects what this witness will say. Ms. Abramson says it doesn't reflect every word he's going to say, just like Dr. McCarthy's report hardly reflected everything. The court says, let's not get into disputes about other witnesses. Let's focus on the yeah, because Dr. McCarthy was a state's witness and he doesn't want to talk about that. The court says, let's not get into disputes about other witnesses. Let's focus on this very simply. Does this report reflect what this witness will say? Yes. The court says not every word, but the substance of what he's going to say. There's something new. There's not something new or controversial that I'll say. Miss Abramson says, Your Honor, if I could be given 2 more minutes to finish reading, I have something in mind that I want to see if it's in here. Virtually everything in his report has already been utilized in cross examination, so none of it should be a surprise. The only thing I'm not seeing on first glance, but should be obvious that we're going to talk about, is the blood spatter patterns on Mr. Menendez's shirt and the blood spatter pattern inside his left arm. And there will be testimony that blood spatter appears on the cushion to the right of the second cushion of the couch, which has also been utilized in cross examination. And there will be testimony as this report indicates, about blood droplets and spatter on the carpet in front of Mr. Menendez's position, about blood spatter on the shoes of Mrs. Menendez. All of that is in here. This is almost all blood spatter evidence. I just wanted to make sure that it also involves, I don't see the specific reference to the left side of the shirt and his inner arm, but he's going to testify concerning those. And if I determine prior to his taking the stand that there's any other additional points that he's going to make about the blood evidence or the ballistics evidence, I'll tell counsel that he's going to say those things so they won't be surprised. But I don't think that there's anything surprising about what he's going to testify to, given the cross examination of the people's witnesses and the testimony of Dr. Fackler. Obviously, they are arguing about this particular witness that is coming up, so they have all this arguing to do, and then they're going to stop in the middle of his testimony, argue, and then come back to him a week later. So it's just like why the state really does not want this person, this witness, to come in. Mr. Khan says, yes, once again, I think we should give a copy or be given a copy of this report to the court because it makes passing references to blood. It doesn't indicate what his opinion is in regard to the blood that is observed at different locations, and it is, from any objective evaluation of it, more of a criticism of the reconstruction than it is a report of his conclusions concerning the blood that was observed at the crime scene. So again, I don't think that we have any discovery to the substance of what he's going to be testifying to. We cannot decipher from his report what his position is in regard to any of the evidence about which he will be testifying, and to the extent that he does criticize the reconstruction, I don't think that they should be able to call the witness for that purpose. He should be able to testify to his conclusions concerning the blood at the scene without getting into criticisms of the reconstruction of the shooting. And we don't know what his testimony is going to be concerning the blood at this scene. Davidson says counsel is not being candid with the court. This is English, and it's easy to understand what he's saying. Moreover, I've never heard any rule that the people propose to put their entire premeditation theory on through the testimony of a Roger McCarthy and a reconstruction that they claim of this crime scene. We have a right to attack it from the expertise of many experts. The court says, again, I'm not addressing that issue. Ms. Amerson says, the point is it. Then the court cuts her off and says, what I'm trying to do is very simply determine whether or not the prosecution has been the beneficiary of the same sorts of discoveries as has the defense. So he's looking for some kind of a loophole, almost, if you will, to see if he can exclude this witness. It seems like maybe you didn't turn over your defense, so I'm going to keep this witness out or do some kind of relief for the prosecution because you made some kind of discovery error. Is that what he's, I mean, it almost seems that way to me, but Moving on. Ms. Abramson says, yes, I would ask the court to compare this to the preliminary and only report that we got from Dr. Lawrence and compare his preliminary and only report that that he testified to on the witness stand. Court says, okay, both sides want me to look at this report, so I'll look at it. Ms. Abramson says, fine. The court says, somebody give it to me. Ms. Abramson says they have to give up one of the two copies we gave them. Apparently, they gave it to their failure analysis associate. Okay. Court says, thank you. There's a pause in the proceedings. The court says, okay, I've reviewed this, and most of this report just appears to be the review of the failure analysis report and an analysis of it. I don't know exactly what Mr. Morton's background is as to his background versus that of the witness who just testified or any other witness that the defense is calling on this subject, but there's very little in here that refers to blood spatters or blood evidence. Ms. Abramson says he talks about the blood on Mr. Menendez's left knee. He talks about the blood on the carpet in front of his body, and he's an expert in the shape of, he's a blood spatter expert. He's a ballistics firearms expert. He's a hair and fiber expert, and he's a criminalist, which means he's an expert on the combination of things on a combination of things. He talks about the blood on his body. He would also testify, as has been brought out through cross examination, that there are blood smears on the dorsal aspect of Mr. Menendez's left hand and blood smears inside of his thigh that indicate that he moved his hands across those thighs at some point after he had been shot in the leg, which supports the notion that the leg is an ante-mortem shot or wound. He talks about the blood patterns on Mrs. Menendez's shoes that indicates that she was standing up at the time when she was shot and that she also stepped in blood. I've already indicated he's going to talk about the fact that there is a blood pattern spray on the cushion on the couch that indicates that someone was shot who was above that position. He's also going to testify that, as this report indicates, that the fact that a piece of her bracelet and a piece of a wadding and a pellet and a blood spray is at the hole in the east door, that indicates the likelihood that Mrs. Menendez was standing when she received the shots to her right arm. I mean, that's all in here. The court says, what else is he going to testify about? Oh my God, why is it not good enough? What is the problem? Put him on the stand. This is 20 more pages of argument they've got. The court says, what else is he going to testify about? Ms. Abramson says, and he's also going to critique certain conclusions that failure analysis is indicating based on the blood evidence and the pellet and wadding evidence as indicated in this report. He's also going to testify to the abrasions on Mr. Menendez's right leg as being related to the wadding that's on his right leg, which no one has testified to because apparently Mr. McCarthy and Dr. Lawrence didn't realize that there was wadding found on his right leg. And I also anticipate, Your Honor, I just remembered the other thing. He examined all of the clothing in this case, and I believe he's going to testify with respect to the holes in the shirt and the possible cause of those holes. And I know he's going to testify that with respect to any so-called pellet holes on the sleeve, that it is impossible, even for a blood spatter and fiber expert, to indicate direction of entry or exit through sleeve holes on a garment that has been removed from the body of a victim that has been handled by other people. So he's critiquing the investigation, and which contains dried blood and bodily fluids because those fluids and blood distort whatever angle or pattern the fibers originally had. And that is a recitation now both from his report and from my memory of all the points that Mr. Morton has raised with me over the past few weeks. Oh, so this is Mr. Morton. Sorry, this is Mr. Morton that they're talking about. I thought it was Cyril Wecht. I was wrong. This is Morton. Um, and she goes on, and I did try to get from him a report that contained all of this in one place, and I will. What is Morton again? Hold on. Morton is the private criminalist forensic scientist. That's why he's an expert in the blood spatter, the angles, of the blood, the droplets, and that's what she was talking about, the fibers. That makes sense. That's why he's an expert in that, because he worked um, probably in a lab, and now he does it privately. He does like private consultations. All right. And she goes on to say, and I did try to get from him a report that contained all of this in one place, and I will still endeavor to do so. And I intended to talk to him later today when he gets out of court, and I will be happy if he will send me these additional points in writing to pass them on to the prosecution if they bother to give me a way to reach them over the next 4 days. Last weekend, we had Dr. Wecht's report, and I told them I would have it for them on Sunday, and they were supposed to give me a way to get it to them, and they never did. Wow. They complained and complained, well, we don't have the report, Your Honor. And then when the defense tries to give it to you, you don't make yourself available. But I'm more than happy to get them whatever other information I can get Mr. Morton to reduce to writing and get it to them before Monday if they'll just let me know where to fax it. The court says, and Mr. Morton is going to be the next witness, or is that still up in the air? It's still up in the air. It's either Dr. Wecht or Dr. Morton. I'll be happy to get whatever I can get by Monday. So either way, they have it in advance. The court says, well, you already have Wecht's report. Is that it? Is that true, Mr. Khan? Ms. Nahira says, Your Honor, we do have Dr. Wecht's report, and the problem with Dr. Wecht's report, of course there's a problem, once again, is something maybe the court's going to have to do. Is it simply going over Dr. Golden's report saying, I agree with this wound, I agree with this wound? That is perfectly acceptable, perfectly um, efficient, or not efficient, but it's acceptable, and it's definitely part of the process. Is when you have when a defense hires an expert, their expert is going to look over the state's experts report and findings, and then they're going to give their opinion on those findings. That's what they're there for. So for her to be like, well, this is only just critiquing our person, that's okay. That's what the defense's experts are for. This is like, what is their legal argument here that they're whining about? They're just whining. They just don't want Morton on because apparently he's that good and that knowledgeable. And he must refute the state's claims. Ms. Abramson says there's two reports. Ms. Nahara says, who is going to testify first? Because there's going to be an objection to whichever, most certainly to Dr. Wecht, if this is his whole report. His report consists of the first report, which I already mentioned to the court from November 13th, basically saying I'm essentially in agreement with the interpretation of this wound. There's like 10 lines from Mr. Menendez and 6 lines for Mr. Menendez. Then there's a supplemental report because there were some things that he couldn't have an opinion on in the first report that he then, in the supplemental report, says, this is what I'm clearing up in the supplemental report. Miss Abramson says, that's not what it is, Carol. He didn't have to give. And the court says, let's not get into little discussions. Miss Abramson says, she's misrepresenting what. Let her finish, the court says. Yeah, it's cool. Just, let the attorney lie to the judge, and I'm not gonna stop her. I'm not gonna be like, no. Okay, whatever. Just keep lying, Ms. Nahara. Essentially, what I'm saying is I can give you a copy of these. The bottom line is there's no information there of any substance as to what he is going to add to this case, I guess, is what I'm trying to tell the court. And if there's going to be a question of their putting on Dr. Wecht before Dr. Morton, there might be a question of whether or not Dr. Morton would testify or whether or not Dr. Wecht would testify, because I think there's going to be a real problem with them testifying after the doctor just testified. What? The court says, all right. I'll have to wait until whichever one testifies to rule upon a motion that has yet to be made. So you have not made a motion, so I can't. You're complaining about a future thing that hasn't happened yet. Ms. Nahara says the second problem is we need to know who's going to testify next because there's going to be a large amount of information that needs to be digested. The court says they're both going to testify next week. So again, this was Wednesday going into um, the holiday weekend. And so so that was another reason why, if they're asking for all this discovery and I'm going to, jump through hoops to go get it for them, then they better be available to provide it to them because it is the holiday weekend and I'm working on my weekends and on my holiday and I don't want to be doing that. And yeah, you know, like be civil, be professional. That's so unprofessional to be like, we want this now, and then I'm not going to make any effort to get it from you when you're putting in all the effort. Anyways, Ms. Nahir says the second problem is we need to know who's going to testify next because there's a large amount of information that needs to be digested. The court says they're both going to testify next week. So, whichever it is, you'll have to get ready. A lot of this is because the prosecution produced this reconstruction evidence at the beginning of jury selection and it wasn't before then. So, at least the judge is like, you know what? This is a lot. This has a lot to do with your behavior and action that you didn't have this reconstruction until we started trial. So the defense, in this position of having to rebut it and gather their evidence to rebut it during the trial, and that's why this material is being produced as it is. And so I can't fault the defense for the lateness of discovery because the prosecution didn't produce its material until jury selection was in progress. That's fair. Thank you, Judge, for being fair there. Ms. Nair says, Your Honor, it's not the lateness of discovery that has us concerned. It's the lack of substance of discovery, I think, is the issue here. The court says, well, again, that has to do with the lateness of their ability to respond or the lack of time to respond to what it is that they are dealing with. At this point, it appears to me that there is sufficient information here given to the prosecution with the addendum if I could speak, with the addendum material that has been recited by Ms. Abramson to give you a reasonable expectation of what is Mr. Morton, what it is that Mr. Morton is going to testify about. And as to any objections that things are cumulative, I'll just have to wait until the evidence is produced. Obviously, if things can be focused and separated for one witness to deal with certain things and another witness to deal with other things, rather than everyone covering the same territory, that would be of help. The defense apparently attempted to do that to some extent with Dr. Fackler, but clearly, from the nature of the direct examination, it was within the scope of the direct examination to permit cross-examination of the entirety of his analysis of the failure analysis report and the testimony of Dr. McCarthy. So remember, the the direct examination by the defense was narrowly tailored, but the judge ruled, well, it was enough that I'll let the state do a really thorough cross examination, going wound by wound by wound by wound, even though that's not what the defense did. It was very bizarre that he allowed that, but he did. Anyways, that opened the whole testimony of Dr. Fackler up to the entirety of the crime scene and all of the issues relating to it. That was done by combination of the scope of the direct examination and the nature of the cross examination. That by itself shouldn't foreclose the defense from putting on additional witnesses to cover areas that they did not directly cover in their direct examination. But again, if things are going to be repeated over and over that are not in dispute, then there very well could be good valid objection to the grounds of it being cumulative. If things are still in dispute and things are in controversy, then the court would have to excuse me, would have to evaluate any objections as they're being made. I can't rule in the abstract of it. So we can't, rule for a future objection that hasn't happened yet. So, anyways, as far as the discovery issues are concerned, I think they're resolved at this point. The prosecution will just have to be ready for whichever witness is available on Monday to testify. Oh, sorry, state. You have to just be ready. Hasn't that been your plan all along to just like ambush the defense with different witnesses on different days and mixing up your schedule of witnesses? And now you have to do it. The judge actually says you just have to be prepared, just like the defense has had to do for this entire trial so far. Thank goodness. And there's some uncertainty on the part of the defense as to which it will be, and the prosecution should make itself available to get more information from the defense if they have it as to which witness will actually be called to testify. Ms. Abramson says we have to call them up on Friday and let them know. The court says so that you can have some means of communication, channel of communication that would be of benefit. As far as other issues here that still are in the state of flux, one of them has to do with exhibits. The testimony of Dr. McCarthy has been completed. I'll expect that counsel will do as you did before, meet and confer and resolve any disputes as possible, um, just as soon as possible on exhibits that have so far been marked and utilized so that we can next week resolve issues of admissibility of the exhibits thus far marked so that we can move on to other issues. Also, there is the motion that the defense indicated it was going to make under the statute and argue it. When did you want to argue that motion? Mr. Gessler says, I think it makes the most sense to argue it after we've decided on exhibits, Your Honor, because there's two parts to the motion. One is the narrowing function, which is an issue of law not having to do with the specific evidence in this case. The second part, of course, is sufficiency of evidence for a lying in wait special circumstance under 1118.1, the statute that they were talking about. Court says, so you don't feel you're in a position to do it until after you've dealt with exhibits, Mr. Gessler says. I don't think so, Your Honor, because it depends on what exhibits the court admits that might be in dispute, most particularly the charts of Dr. McCarthy or the illustrations or whatever we want to call them. The court says, all right, I'll give you until we argue the exhibits to then argue your motion under 1118.1, but I don't want to get these things delayed too much. Mr. Gessler says, I don't either, Your Honor. Like I say, the part about the constitutionality under the 6th, 8th, and 14th Amendments is independent of any evidence that is presented in this case or at this time or any other. Court says that's the arguments that have previously been made, basically. Mr. Gessler says they've basically previously been made, but it's on the overbreadth of lying in wait special circumstance as written and as interpreted by our state Supreme Court and decisions. And I do take a different position from that of Mr. Burt in 1993. Mr. Burt, I believe, was for Lyle's defense team. He was one of the members of Lyle's team with Miss Lansing. The court says, okay, rather than getting into it, if you want to argue it, I'll certainly give you the opportunity to do that. But if it's different than what was presented before, then we'll do it all at once. It would make sense that it's Lyle's attorney because this is also Lyle's new attorney speaking. Mr. Gessler says, all right, I just wanted to let the court know it's different in breadth and that I do not concede that more Morales, if you follow Morales, that satisfies. So Morales is another case. I'm assuming that satisfies the problem. Basically, I think even that Morales is suspect under constitutional tests, both it and its prodigies. Court says, okay, all right. Mr. Gessler says, the other thing, Your Honor, has the court ruled or been able to rule on the out of state witness request? Court says, I looked at it. I basically didn't study it in depth. There are actually two requests. Mr. Gessler says they're alternative, Your Honor. The first is a request for attendance of out-of-state witness. The second one is actually almost a fallback position because I believe one of the requirements for the out-of-state commission is unavailability, and the unavailability would be if the court denies our first one, which is the one that we're asking for first, which is the attendance of the out-of-state witness. Even though it's for a very quick testimony, it is essential since the prosecution is objecting to it. The court says, well, as I said, I haven't read the declaration. I read the document itself, the handwritten document, but I didn't read the declaration, and whatever argument you've put it in as far as materiality and relevance, I don't know if there is any there. Mr. Gessler says, yes, there is, Your Honor. The materiality and relevance goes largely to the geniuses of any document, genesis, gen- of any document written by Lyle. I think he's saying Genesis. Of any document written by Lyle because of other aspects of, that's not how you spell Genesis, though, is it? It's, okay, anyways. The creation of any document written by Lyle Menendez because of other aspects of documents written by him, most particularly the Brian as Laminia evidence presented by the people. The court says, okay, let me ask you this. I haven't read the material, so I'm a little bit in the dark, but assuming your client doesn't testify, how would this be admissible evidence? And remember, in the first trial, Lyle did testify. In this trial, he doesn't because of the whole credibility issues that came up when he supposedly asked people to lie for him. Mr. Gessler says, well, not supposedly, he's admitted it, so I'm not even going to say supposedly, but I don't know to the extent that, the things that Eslaminia was stating or what's the name of the girlfriend? Pizarsic, Jamie Pizarsic. I I don't know if I believe everything that they said either in their testimony. They had some credibility issues as well, so just a reminder. But that's what they were talking about was the Eslaminia letter, is that Lyle um, asked Brian Eslaminia to lie about uh, asking for to borrow a handgun when they were around the times of the homicides. All right, so Mr. Gessler says it, I believe, is admissible because of the proposed testimony of Dr. John Wilson, who is also looking at and relying upon this document for some of his opinions. The court says, and how does he come to an interpretation of it other than through statements of your client? Mr. Gessler says, through also statements of Erik Menendez, Your Honor. The court says, and how does Erik Menendez know the meaning or significance of that document? Mr. Gessler says, well, I believe that he has discussed this document with Dr. Wilson, Your Honor. Court says, well, I mean, how does he know the significance? What is it? He wasn't the author of it. Mr. Gessler says, he was not the author of it, Your Honor, but he has knowledge of it. As of when? Your Honor, I think we're getting into discovery of proposed testimony of a defendant. Court says, I'm just trying to find out if it's relevant. Mr. Gessler says, I know. Court says, and at this point, the only way I could see it being relevant would be if Lyle Menendez was to testify and was to authenticate his document and it became relevant during his testimony. Mr. Levin says, I think what I can say, Your Honor, with respect to Erik Menendez is that Erik Menendez is aware of the contents of this particular document long before August 20th, 1989, and there is certain information that is relied upon or believed to be true within that document that has a direct bearing upon Erik Menendez's state of mind with respect to the events preceding the homicide of the 20th. Court says, I'd have to hear that testimony before I can rule on this. Mr. Gessler says the problem then becomes, Your Honor, a delay that might be necessitated in the trial if the court did not rule it relevant until such time as Dr. Wilson had testified. We then would have to get the documents back to New Jersey, set up a hearing in New Jersey for the witness who's entitled to certain notice and representation there, and then deciding whether or not she shall be ordered to come out to California to give the testimony. The court says, well, again, I couldn't sign a declaration saying that this is material evidence because I can't find at this point that it is from what has been presented to me. I would be hard pressed to say that it would be admissible or relevant evidence. So I couldn't sign the document. I would have to decline or rule against you on it. I just don't see how it's admissible or relevant at this point from what's been presented to me. Mr. Gessler says, if the court is going to rule against bringing the witness out, would the court then consider the alternative of the interrogatories type procedure, which then, if the court rules is relevant, it's not a great waste of time and effort of everybody in New Jersey. It's simply an interrogatories procedure or commission procedure, and it would then take away the necessary delay in the court after hearing the defense evidence. Does agree with us that it's relevant. The court says, well, is this woman resistant to coming here? Mr. Gessler says she basically is resistant, Your Honor. We have not specifically asked her to come out here, but from prior conversations, I can tell the court she's resistant. Court says, okay, well, at this point, I'll read your material and get a better feel for it. I'll have to give you information on Monday as to how I feel. Mr. Gessler says, I would ask the court to consider this declaration. The court says, as I said, I'm just giving you my off the top of my head reaction to looking at the document itself, the handwritten document, as to how I reacted to it without reading your declaration. I haven't read the people's position yet as to their position as to the authentication of the document or its admissibility, but I'll certainly hear from them as well. I want to read it first. I just got it this afternoon, and I'll let you know on Monday. Mr. Gessler says, thank you very much, Your Honor. Anything else? No, Your Honor. Okay, we will be in recess until Monday, and time flies, and we begin Monday morning. Why am I not on page one? Sorry. So that was November 22nd, and we have completed that week, which was week 7 of the trial. We now begin week 8. So that was all argument leading up into Morton's testimony. Now we're going to have a little bit of Dr. Wecht's testimony, and then it's going to cut for a ton more argument. So just be prepared. But we're only going to get through Wecht's testimony, and then we're going to finish from there. So the court says, we're in session with the defendants and counsel here. Mr. Gessler isn't here at the moment. You wanted to say something about this witness. Ms. Abramson says, I just wanted to indicate that what our intention is on direct with this witness in the hopes that we can examine him as expeditiously as possible. He has been here once before and did not get on the witness stand. So I'd like to have his testimony completed, if possible, by the end of today. This does not happen. This does not happen because he has to come back the following week, as I've told you already. If not early tomorrow. My intention with Dr. Wecht is to take as his second report, which was turned over to the prosecution, indicates, to take him through the so-called controversial wounds on each of the each of the decedents, and above and beyond that, to talk about his experience in so-called reconstructions and his opinion about when reconstructions are possible and not possible, and what are the factual predicates to do a reconstruction on a shotgun shooting, and his opinion as to whether or not, from his forensic science background, he believes a scientifically valid one was possible in this case. So that's basically the scope of the testimony I intend to elicit. I do not intend to take him through the cartoons, the illustrations, as I found I had to do with Dr. Fackler after cross examination was as broad as it was to refute step by step failure analysis work. So, it is not my intention to take him through those illustrations, basically, is all. And I intend to use, with respect to his discussion of certain wounds, photographs that are on the boards that we have for the wounds where photographic evidence is useful. So that's my intention, is to try to do a fairly expeditious and to the point examination of this witness. I think this jury has heard a great deal about the evidence by now, and I don't intend to be duplicative, but this is the only forensic pathologist that we have called, and he does disagree with the forensic pathologist that was called by the prosecution, and so I think we have to go through those areas of controversy. All right, and what is the purpose of your remarks? Ms. Abramson says, well, the purpose of my remarks is that I would like the court to, I know the court is not going to make a ruling now because anything can happen, but I want the court to know where I'm steering so it's clear. When my direct is over, what its purpose is and point was so that the people are not then in a position where they can examine him beyond the scope of that direct examination like they did with the last witness. Well, I'm not going to, Miss Abramson says, I know, allow the people to call Dr. Wecht as their own witness and go beyond the scope of the direct, but I cannot at this point determine what the scope will be until I hear this testimony. So we'll now have the jury out and we'll proceed. Thank you, Your Honor. So she's basically saying again, like, I don't want you to open this up. Like, I'm narrowly doing this. She's letting the judge know and ahead of time. I'm narrowly tailoring my direct so prosecution can't go all over the place in their cross because that was allowed with the last witness. And he basically is like, whatever, move on. I can't make that ruling now. I can't determine if I'm going to let them go beyond the scope right now. So, whatever. Okay, so Ms. Abramson says, thank you. The court says, we have one juror who's feeling a little under the weather, so we might take more breaks than normal. The jury enters the courtroom and the following proceedings are held. All right, so the court says, okay, the jury is here. Good morning, ladies and gentlemen. We'll now resume with trial. The witness is here, so the defense may call its next witness. Ms. Abramson says, thank you, Your Honor. The defense calls Dr. Cyril Wecht. Cyril Wecht is called and sworn in. He raises his hand. He does all the stuff. Direct examination begins. Ms. Abramson says, what is your occupation? Physician, specializing in pathology, anatomic, clinical, and forensic pathology. Those are three separate disciplines, FYI, of pathology. So he's like a pathology nut. He's there's multiple areas of pathology, and he's basically specialized in all of them. And how long have you been a physician? I graduated from the University of Pittsburgh School of Medicine in 1956, a year of internship. So the MD degree 56, the state license upon completion of internship 1 year later, about September 57. And did you do a residency in pathology? Yes. After the 1 year of internship, I did a 5 year program in pathology, 2 years at the University Veterans Administrative Hospital in Pittsburgh, 57 to 59, 2 years in the United States Air Force at Maxwell Air Force Base, Montgomery, Alabama, where I was a captain of the Air Force and served as an associate pathologist. So we've got another military doctor. So the defense team is getting some good experts for their case. Dr. Fackler had 30 plus years in the Navy and Army combined as a trauma surgeon. And this doctor apparently got 2 years of his pathology internship at with the Air Force here. So, and he served as the associate pathologist, not just, that he did it, but he was also in a leadership role here as as an associate pathologist. And then the fifth year was a fellowship. I was a researcher fellow in forensic pathology and associate pathologist in the office of the chief medical examiner in the state of Maryland. That was in Baltimore from 61 to 62. That finished the 5 years of pathology training after the 1 year of internship. And in the summer of 62, I returned to Pittsburgh, which had been my home. So for the past 3 years, 3.5 years, I had been practicing in Allegheny County, which is in Pittsburgh and surrounding southwestern Pennsylvania counties. Um, yeah, so he's got a lot of experience with this. Do you currently hold a public office in Allegheny? Yes and no. I was elected coroner of Allegheny 3 weeks ago, but I don't officially take office until I'm sworn in on January 1st. So he's the elected coroner of a county. So he just hasn't taken office yet. And have you been the elected coroner of Allegheny in the past as well? Yes, I was the elected coroner for 10 years, from 1970 to 1980, the chief forensic pathologist in the Allegheny coroner's office for 4 years after that, 66 to 70. And what is the function of strike that? You're aware that different counties and different government agencies have different types of coroners? Yes, I have written on this. Okay, and you're familiar with basically the role and the type of coroner that Los Angeles County has? Yes. And is the coroner's office in Allegheny different? Well, the coroner in Allegheny is still an elected official, and Los Angeles County, he or she is appointed. The roles then are essentially the same. So, a government official appoints someone to be that person, whereas the people elected him. The roles then are essential, the same. In theory, the role of any official, governmental, medical, legal, investigative office is the same: coroner, medical examiner, to determine cause of death, manner of death, mechanism of death, sometimes time and place, sometimes sequence, relationship of injury to disease, disease to injury. Then, in modern day times, in a society like ours, we deal with many other things: environmental pollutants, air, land, water, toxicological substances, drug, alcohol problems, SA type things, injury patterns, and so on. So these are the kinds of things that a forensic pathologist gets involved in, and the medical examiner or the coroner's office has the official responsibility in death cases of issuing the death certificate and setting forth the cause of death and the manner of death. In the way that the office is structured in Allegheny, do you serve in cases of suspected homicide? For instance, do you have a magistrate like function? Yes, as well as a medical examiner function. Yes, the coroner of Allegheny sits in a kind of a quasi magisterial position. Every known suspected or alleged, or for that matter, possible homicide case, or a case in which homicide charges might follow, that case must be presented to the coroner's office, and that's without exception, be it automotive, vehicular, up to any and all kinds of manslaughter, murder cases, and so on. That's been the function and is the Allegheny coroner. When you say must be presented, who must present it to the coroner's office? The case will be presented by one of the district attorneys as assistant district attorney, and the witnesses will be determined by the coroner. The district attorney has a lot of input on that, of course, because as in any situation like that, a prima facie case must be demonstrated to determine if there is a homicide. And if so, whether the charges should lie. And do you have the authority as the elected coroner when you're in office to decide these issues on your own, or must you impanel a coroner's jury for that purpose? You can do it on your own. You have the prerogative, but it is not mandatory to convene a jury. And in your experience in the past, would you make these determinations and judgments on your own, or as to whether would you make these judgments on your own as to whether certain deaths were homicides and that charges should be filed against those who have caused the death? My God, I can't get words out right now. I would say maybe in about 90% of the time, the determination is made without a jury. Roughly 1 out of 10 will have some societal conflict, some issue of concern to the public, and in such instances, a jury may be impaneled. So, when it's a case where the public may have an interest in it, you would then impanel the jury. When I say an interest, the public is often interested in many cases, but I mean something that might be a public health matter. It might be a problem involving a racial or a religious or nationality issue. It might be something involving a police agency, such as police shooting or a questionable death in a jail. Is it a, self deletion, or is it a homicide? In those kinds of cases, we found that it's better for everybody to have a jury. The jury comes over from the criminal justice panel sent over by the presiding judge of the criminal division. We don't handpick them. Now, in the 33 and a half years since your completion of your residency in pathology, have you performed a number of autopsies? Yes. And how many autopsies have you personally performed? Well, going back to the residency, actually a few in internship and then going back to the residency because the load was pretty heavy too. Okay, I would say going back 38 or 39 years that I have performed about 13,000 autopsies myself, and I have reviewed, supervised, or signed off on about 30,000 other autopsies. When he said he was busy, he was busy. That's a lot of autopsies in his career. When you say you've reviewed or supervised, are these autopsies that were performed in either the coroner's office or in hospitals with which you were affiliated mainly? Yes, the ones in which I have supervised or signed off on were performed by the pathologists who work on my staff at the coroner's office, and some by pathologists at hospitals with which I have always been affiliated. And when I refer to cases which I have reviewed, those are cases that have come up to me in consultation for one purpose or another, where an autopsy has been done by someone who's independent of me or my office or position and have been given the autopsy material, the protocol, and microscopic slides, sometimes the tissues. So, those are the kinds of cases which I refer to as among those that have been reviewed. Okay. And have you been a private consultant in effect in litigation where you have reviewed previous autopsies in cases that are in litigation, either civil or criminal, and testified as an expert witness in those cases? Yes. And on how many occasions have you, in that capacity, testified in courts? Let me break it down. As the coroner, I take it you've testified a great deal in Allegheny on coroner cases. Yes. I'm addressing now the private consulting aspect of your professional career. In approximately how many cases outside of Allegheny County have you testified? Well, including civil and criminal cases, including the homicide cases in which I've testified for another county for whom I perform medical legal autopsies as their forensic pathologist, but on an independent basis, so to speak, contractual agreement with those counties, including all of those, and workers' compensation cases and black lung. We have a lot of retired coal miners and steel workers in Pittsburgh, Allegheny County, and I do a fair number of those autopsies, and I testify, I would say, Well, certainly more than 500 times. And you qualified as an expert witness in forensic pathology in those cases? Yes. I have testified, I think, in probably more than 30 states, in mostly state courts and several federal courts, and I have testified in probably about one half of the 67 counties in the Commonwealth of Pennsylvania. And have you been consulted, or were you consulted, Dr. Wecht, in some rather famous or well known cases over the years? Yes, I have been. And can you tell us what cases you were consulted on that have some notoriety? I was consulted in 3 cases here in Los Angeles that I think had a fair amount of notoriety. And what were those? One was the assassination of Senator Robert F. Kennedy. I, in fact, came out here a few days afterwards. I was actually in consultation starting before the senator was dead. And how did that happen? Dr. Thomas Noguchi, who was the chief medical examiner coroner of Los Angeles County, called me at his home after the shooting and wanted to talk about how to avoid some of the problems that occurred with President Kennedy. He didn't consult me on how to do an autopsy. He's an outstanding forensic pathology. He didn't need any input from me. He knew of my involvement and interest in that case. In the JFK assassination, yes, in the John F. Kennedy assassination, he wanted to make sure the body wasn't taken from California illegally, as had been done with President Kennedy from Texas. What? He's talking about Robert F. Kennedy, but he's comparing it with John F. Kennedy and other things. So that was one case. And I came out and I reviewed everything and I went to the Ambassador Hotel where the shooting occurred. I was an official consultant to the office of the Charles Manson murder cases, Sharon Tate, the LaBianca family, and I was a consultant to that. And the Symbi, 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 how do you say that? Something Liberation Army, Symbionese Liberation Army, the death that followed the abduction of Patty Hearst, and the questions that arose pertaining to those deaths. The deaths near Los Angeles by fire? The question was fire, gunshot wound, were they alive or dead before the fire, things like that. You said you were a consultant in those cases. You were a consultant to the LA County Coroner's Office? Yes, in those 3 instances, that's correct. I was consultant to District Attorney James Garrison in the Clay Shaw case, which was related to the John F. Kennedy case. I later testified before the Rockefeller Commission in Washington, D.C. in 75 on the JFK case, and I was 9 of forensic pathologists on the forensic panel of the House Select Committee on Assassinations appointed by the United States Congress in 77 to review the assassination death of President Kennedy and Dr. Martin Luther King. I was consultant in the Klaus von Bülow, Sonny Van Bülow case. I was consultant in the Gene Harris shooting, Dr. Herman Tarnauer, the so-called diet doctor. I don't recognize those names because it's been so long that I don't think these people, I don't know, um, I don't know, they might be more time relevant. I don't know. Do you guys remember these individuals? The Bulow case kind of sounds familiar, but I can't remember what it was about. Herman Tarnauer, no idea, the diet doctor. For whom were you a consultant in the Von Bulow case? To attorney Alan Dershowitz. He was representing Mr. Van Bulow in the second trial. And whom were you a consultant for in the Gene Harris case? Defense attorney Joel Arno. I was consultant to ABC National Network for the death of Elvis Presley. And how was ABC involved in the death of Elvis Presley? Well, they wanted to get a hold of all the records and they wanted to review the autopsy and the toxicology reports. They were interested as a news media organization in what killed Elvis Presley. Did you have access to those materials? Yes, eventually I had access to those materials. So you reviewed those materials? Yes, and I was interviewed by them. The court says, is he dead, by the way? The witness says, Your Honor, there's one more Greek island to be checked for it to be stated with certainty. I have been I've been consultant to governmental agencies in Taiwan on two controversial deaths of prominent political figures, to the country of Pakistan in the exhumation and autopsy of their former commander-in-chief of the army, who was thought to have been poisoned. I was recently a consultant to the Singapore government in a case involving the death of a Filipino maid in Singapore, in which another Filipino maid was charged with murder and was subsequently executed by the Singapore government, a very controversial issue between those two countries. I was more recently a consultant to two attorneys in the Waco compound fire and did second autopsies on David Koresh and Steve and Judy Schneider, his right hand man and wife. All right. So he has done a lot of famous cases. And by famous, I mean like infamous cases that most people would know. Some of them I didn't know, but most of them I did. So you actually did an examination and autopsy of the body of Mr. Koresh. Yes, at the Fort Worth Medical Examiner's Office. I think that's Tarrant County. That was the second autopsy they had already done. Yes, but there was a great deal. There was a criminal prosecution that resulted from Waco. Was your second autopsy done in conjunction with that prosecution? Yes, and I think there was some civil matters. I'm not sure if they're pending or what's going on. I think there's some civil litigation too, because of the way that the government handled that situation was totally out of control. Firepower, military, women and kids burning inside. They didn't need to, it didn't need to come to the way that it did. And yeah, so there are, I assume people sued the government for the way that they handled that situation. All right. Now, I don't think we completed all of your educational background. At some point, you determined that forensic pathology would be your particular specialty. Is that correct? Yes. And when was it that, well, could you explain just very briefly what's the difference between a pathologist and a forensic pathologist? Pathology is divided into two major categories, anatomic and clinical. Anatomic deals with the study of tissue, all specimens removed by doctors at hospitals. The study of cells on slides is the most common and well known, which would be the pap smear. But we do that with other body fluids. So that's all anatomic. Clinical pathology includes many different areas. All of those things you'll see depicted sometimes in movies where people are working at the benches: hematology, chemistry, immunology, serology, blood banking, transfusions, urinalysis, microbiology, which is subdivided into bacteriology, viruses, fungi. All of that is clinical. Those are the two major distinctions then. There are appropriately 8 or 9 officially recognized subspecialties that require additional training and have their own separate national examination for certification. One of these, created in 1959, was forensic pathology, and it requires an additional investigative office, coroner, or medical examiner. You have such an approved program here in Los Angeles. San Francisco has one, and so on, that deals with the kinds of cases that we talked about: violent, sudden, unexpected, unexplained. Medically, you want to determine cause and manner. And like any medical field, it involves teaching, writing, research, and you can be an independent consultant, and we've talked. But that's what forensic pathology covers. And I think you've already told us about the additional year that you did in the coroner's office. Medical examiner's office, right. They have an appointed medical examiner, and that was a fellowship that I did there. And that was what qualified you to take the examination in forensic pathology? Yes. And if you take the examination, does that result in what's known as board certification? Yes. There were 24 national boards, primarily board specialties, and about 28, 30 subspecialty boards. And they're all called American Board of Obstetrics and Gynecology, American Board of Surgery, Board of Internal Medicine. Ours is the American Board of Pathology. To take the examination with women and men from all over the country, we have finished at who have finished at accredited places. Then you take it, and if you pass, then you are referred to as having been certified by the board. It's the same examination for everybody. California, Maine, Washington, Florida, it's the same exam. And when were you board certified in forensic pathology? In anatomic and clinical, first as a necessary prerequisite in 1963 and forensic pathology in 64. And did you seek an additional educational background to assist you in forensic pathology because of its interaction with the courts and the legal system? Yes, my internship, when I had decided that I wanted to into pathology and forensic pathology, I felt that that it would be good to learn something about the law. So I went to the University of Pittsburgh School of Law from 57 to 59. That was interrupted by the Air Force, which didn't care about me being a law student, and I did the third year at the University of Maryland School of Law when I got out of the Air Force, 61 to 62. I got my law degree in June of 62 from the University of Maryland, and I got the same degree from Pitt, but it's the same degree, just one earned degree. So you have got a JD degree just like we have? We, the lawyers? Yes, that's right. Have you ever practiced as a lawyer? Very little. I'm licensed to practice in the state of Pennsylvania and the federal district. I even went down to the United States Supreme Court with a group from the Bar Association. I haven't had any cases there yet. I've done a few things to help friends. Sometimes I represented a couple of doctors in some matters at hospital hearings, disciplinary measures, and things like that. I've done a few things where I've been able to write a letter, make a phone call, but I don't really practice law in terms of taking cases and following through and filing motions and going into court. I just have never had the time. So you basically practice forensic pathology. Hospital pathology always, and forensic pathology, and I've also been involved with a private pathology laboratory, not at that time, but for many years, my own, and then as a consultant to other private pathology laboratories. My chief position now is chairman of the Department of Pathology at St. Francis Central Hospital in Pittsburgh. Since the hospital since the hospital opened in the summer of 74 and currently president of the medical staff. Would you continue when you resume the duties of coroner, or do you have to leave the hospital? No, I don't have to leave, and it will continue. When I was a coroner before, from 70 to 80, there was an overlapping of 5.5 years. I just mentioned the hospital opened in the summer of 74 and have been there since that time. So I was a coroner from September of 74 to 1980, and there was that 5.5 year period, and there's no problem. The board and the nuns and everybody, they know me, and I have this was discussed with everybody, and there's no problem. So you'll be able to maintain your position at the hospital and your county elected office. Yes, fortunately, they're about a 2 minute ride and 5 minute walk apart from each other. It's just a longer day, but I'll be able to do it. And have you had over the years teaching positions? Yes, I have. And you don't have to go through, you have a resume that's about 45, 50 pages long. I really don't know. It includes the bibliography. Maybe the numbers are on the top. Wait a second. Some of them, they are unnumbered, most of these pages. All right, this is it, right? It's the one I had given you, or my secretary sent to you. Right. If you could just give us highlights of your teaching career. Well, for many years, and at the present time, I had 6 faculty positions. Not all of them go back as far, but all of them have been in places for several years and some much longer. I have 3 at the University of Pittsburgh. I'm associate adjunct professor in the Department of Pathology at the School of Medicine at the University of Pittsburgh. I'm an adjunct professor of epidemiology in the Graduate School of Public Health, and I'm an adjunct professor of pathology at the School of Dentistry at Duquesne University, Duke, I don't know how you say that, in Pittsburgh. I'm an adjunct professor in the Graduate School of Health and Science, an adjunct professor in the School of Pharmacology, and an adjunct professor in the School of Law. How does this guy find time to eat, sleep, have meals? He does a lot. So you have taught various courses in the School of Law. Were those relating to forensic pathology and law? Yes, I've been teaching a course in law school on a regular basis, given each year as an elective in legal medicine. For some years, I taught a second course, psychiatry, is in the law, but not for the last 10 to 12 years or so. And in that course, I tried to deal with forensic science as well as medical legal problems of a broader nature, like organ transplantation, right to die, AIDS, and things like that, medical malpractice, and so on. And then I included hard forensic science. What as uh, what as a coroner medical examiner are your duties, and so on. Now, have you also been a member of an active member of various professional organizations? Yes. And are there a number of medical professional organizations that you are interested in and that you have been active in? Yes. And what are they, and what's been your participation? Well, I've been a member of our county, state, and American medical associations for many years, the local and state pathology organizations. I'm a fellow of the College of American Pathologies. I'm a fellow of the American Society of Clinical Pathologists. I'm a fellow and former president of the American Academy of Forensic Scientists, fellow and former president of the American College of Legal Medicine. I'm chairman of the board of trustees of the American Board of College of Legal Medicine Foundation. Chairman of the board of trustees, how does this guy sleep? Of the American Board of Legal Medicine, which gives certification examinations to women and men who have degrees in both law and medicine from the United States or Canada. I'm a fellow of the British Academy of Forensic Sciences, fellow of the Royal Society of Medicine of Britain. I'm a fellow and former vice president of the International Association of Forensic Scientists, fellow and former advisor of the International Academy of Legal Medicine and Social Medicine, fellow and former society fellow and former secretary general and then vice president of the International Association of Accident and Traffic Medicine. I'm an honorary Light Fellow of the American Society of Law and Medicine and of the National Societies of Forensic Sciences and Legal Medicine of Spain, Belgium, France, Yugoslavia, Mexico, Brazil, and Colombia. So he's representing countries that don't even exist anymore. Got it. Yugoslavia does not. All right. So what does it mean to be a fellow of these organizations? I mean, are there levels of membership, if you will, in these organizations? Yes, in most of these professional organizations in medicine, in law, In scientific fields, they'll have different levels and it varies somewhat, but the highest level of active involvement is fellow. You reach a certain age, you can be an emeritus, and you don't have to pay dues. Usually, you start off as a provisional national member and then a member, and then after you do a certain number of things, maybe attend certain meetings, present papers, submit papers to be published in their journals, and so on, then you can be moved up to fellowship. Those requirements vary from one organization to another. Speaking of presenting papers, do you participate on a regular basis in teaching in seminars and presentation of technical papers to various groups? Well, I wouldn't say on a regular basis. The regularity pertains to fixed programs in graduate schools. Other things, I'm invited to some. The themes often vary. For example, I've spoken 4 or 5 times in a row, either one or two, or the other out of state invited speaker at the Texas Trial Lawyers Association every year in the fall. But most other things are by invitation and they come whenever people choose to invite you. When I meant regular, I meant on an annual basis. Is it likely you would be invited to give speeches and papers and lectures to professional organizations at least once? Oh, yes, yes. A fair number each year, but when you say annual basis, it's not fixed. Right. In fact, in the last, say, month and a half alone, how many such programs have you participated in? Well, in the past 6 to 8 weeks, there were two that I organized and was the moderator. One was a 2 day seminar at Winnipeg School of Law in New Haven. I know I didn't say that right, Connecticut. Dedication of their new law school building, and I organized, at the request of the Dean and Board of Trustees, a 2 day forensic, scientific, and medical legal seminar for attorneys and forensic scientists and others, as well as their faculty and students. That's a great way to combine resources, I think, attorneys and forensic scientists. To have an association or some kind of organization for the two of them, or these, these 2 day seminars that they can go to learn from one another and network. And I think it's a really neat idea. I don't know if we're still doing this in forensics, but we should. Then, about 3 weeks ago, I organized a day and a half postgraduate seminar for state appellate court judges in Pennsylvania. That was a request from the Supreme Court Justice in charge of the Education Committee through Duquesne University, and the dean asked me to put together the program, which I did, and that was held for those appellate court judges in a community outside of Pittsburgh. And have you, in conjunction with, well, strike that, you participated over the years in research or projects for which you've published or written papers or monographs or books? Yes. I don't consider myself a basic or primary researcher. I don't work with animals in the lab or things like that. I've been involved in several research projects that have been through the coroner's office, some in hospitals, which have been affiliated. I've done research in terms of the medical, legal, forensic, scientific research or literature, but I don't consider myself a basic or primary researcher. I've published, a fair number of articles, but I don't consider them to be basic research with a couple of exceptions. All right, and approximately, I have your biography here. Would it be fair to say your bibliography consists of 334 entries? Yes, there are a few more. I have about 340 articles of different kinds in those fields of forensic science, forensic pathology, legal medicine, and so on that have been published, mostly in national and international journals, some of regional, and they're covered a wide range of things, the kinds of topics we've talked about. 340 articles he's written for journals. So they're probably scientific. quite scientific. And when you talk about those journals, are most of the articles published in what are known as peer-reviewed journals? Well, it depends on how you define peer review. Well, don't you define it? Why don't you define it for the jury? Yes, well, there are a bunch of them. I would say at least 50 where they were reviewed by they were not reviewed by anybody but me because they were publications that I'm responsible for. In other words, you were like the editor, or yes, exactly. I have a legal medicine annual that's been out since 1969. So he also has a magazine of his own. And I have several chapters I've written. I have a 4-volume set of forensic science. Again, when does this guy sleep? Since 1981, semi annual supplements, and I've contributed to that. And then I'm editor of a publication, Scalpel and Quill, but out by Pittsburgh Institute of Legal Medicine, of which I am the president and have several things published there. So he's also the president of this legal magazine or legal medicine magazine. Wow. So I would say 50 to 75 probably. Nobody's reviewed but me. So out of those 340 articles, only about 50 to 75 have been just reviewed by him, not peers. So the rest of them have. Okay, and the others have been reviewed by some kind of peer. That's peer review with some publication which requires that articles be sent out to usually 2 people. You don't know who they were. They're qualified in the same field that you're writing in. Well, exactly. That's the idea. And then others are reviewed by other peers, maybe in a less formal way, but they're reviewed by other people who have to make a decision whether it's going to be published. So peer review is a phrase that has specific meaning and it also has broader significance. Well, generally speaking, though, in medicine and scientific publications, is peer review meant to be a way to assure that only scientifically acceptable materials get published in those journals? Yes, I guess that's one objective. Do you want to elaborate on that as to any other objective? I don't think it's relevant. I mean, as far as I'm concerned, what you've stated is correct. All right, now turning to this case, were you submitted where you submitted certain materials to review pertaining to the autopsies of Jose and Mary Louise Menendez? Yes. And can you tell the jury can you tell the jury what materials specifically were pertaining to the autopsies that were directly submitted to you? So basically, he was hired on by the defense. The defense submitted autopsy reports and things like that so that he could review them. I received copies of the 2 autopsy reports. I received copies of the 2 brief amended reports, followed by the pathologist who did those 2 autopsies, Dr. Irwin Golden. One was in 92 and one was in 95, I believe. Those are the amended dates and autopsy photographs. So the crime happened in 93. So the first autopsy was in 93, the second one was in 95. And excuse me. And then there were photographs of the bodies taken at the scene, which would correlate with the autopsies. Then there were diagrams taken or made of the scene. And then there were diagrams and photographic representations using mannequins made by. Well, let me stop you there. Oh, first, I wanted to focus on materials that actually were primary source materials having to do with the autopsy. Yes, okay. There were crime lab reports and, of course, police detective investigative reports. Those were the primary things generated by what I would call governmental agencies of Los Angeles. Now, I think I mentioned all of the items that would be both official, primary, and directly related to the autopsies. Now, were you also furnished with some diagrams and photographs that they were created by a company called Failure Analysis Associates. Yes, I received quite a bit of material prepared by Failure Analysis. Did you also receive a report prepared by Failure Analysis and signed by a Roger McCarthy and a Devender Grewal? Yes. Now, did you talk with Dr. Martin Fackler concerning aspects of the autopsies of Jose and Mary Louise Menendez? Yes. On one occasion, a week ago, Sunday, here in Los Angeles, at your office. Did you ever talk to Dr. Golden concerning these autopsies? No. Was it your understanding that Dr. Fackler had met with Dr. Golden? Yes. And did Dr. Fackler relay to you any information without telling us what that he had obtained in talking to Dr. Golden? Yes. And were you able, Dr. Wecht, that there were two other forensic pathologists? Were you aware that there were two other forensic pathologists that the defense had consulted, Doctors Michael Baden and Barbara Wolf? That is the Michael Baden. I looked it up, and he just did a little bit of consultation, nothing big. He didn't testify or anything like that, but he did review the autopsy reports and things like that. The world-renowned Dr. Michael Baden, who has had a lot of relevance lately in Sandra Birchmore case recently, and something else. Oh, Epstein. He did an autopsy review of that as well. So he's been really relevant in cases lately in the news. Mr. Khan says objection calls for hearsay, irrelevant. The court sustains it. Ms. Abramson says, well, did you ever discuss any of the issues surrounding these autopsies with Doctors Baden and Wolf? Yes, on several occasions. And were those conference calls in which I participated as well? Yes, I think there have been a couple in which you were not on the line, but most you initiated the calls and set up the arrangements for the conference call. So you had talks with Doctors Baden and Wolf, just among the three of you, and there were other calls when I was on the line as well, correct? Yes. Now, as a result of receiving all this information, the primary and police and coroner's information concerning the autopsies of Jose and Mary Louise Menendez, did you form certain opinions about certain of the wounds that were sustained by each of the decedents? Yes. And what I would like you to do, Dr. Wecht, is take you through some of these wounds. And what I would like to do is start first with Mary Louise Menendez and certain wounds that were observed by Dr. Golden in photographs of her body. Did you prepare a brief report on November 19th, 1995 about Mr. Levin says, Your Honor? The court says, yes, go ahead. I'm, uh, the juror says, I'm not going to make it. The court says, you want to go in the restroom? The juror says, yes. Are we taking a recess, Your Honor? The court says, yes, we'll take a recess point. Thank you, Your Honor. The jury exits the courtroom. And that is where we're going to end up because when they come back, they just go into argument. So I think the jury must be sick. The juror must be sick. Um, I don't know. They went to the men's room, but they'll be back. They're saying, okay, so whatever happens, happens. This is a short day because it's only 100 pages. So we're about halfway through it, and we'll read the arguments in the next stream. I just wanted to get us through Cyril Wecht's testimony, who is for the defense. He's a forensic pathologist, very, very skilled and knowledgeable about pathology, because, as you know, the pathologist, the actual coroner in this case, did not testify. The state did not call them. Why? I don't know. But they decided that they weren't going to call them. And so we had some pretty terrible witnesses for the prosecution regarding ballistics and the wounds and how it all played out. But it seems like the defense is trying to do some of uh, their attempt at, discrediting and, attacking the from the testing from the mechanical engineer, Dr. McCarthy, and then Dr. Lawrence, who is the pathologist who reviewed the actual coroner's report. So basically, he's just a consultant, just like they are on the defense's side, but he's obviously siding with the state, even though there's really mm, not a whole lot backing what he's saying. And I think that the science lays more with the defense, if you ask me. But that's how it is appearing to me at this point. If I'm wrong or if you disagree, please let me know in the comments below. I'd love to hear what you guys think. Um, so just to let you know, the next stream is going to be most likely all argument, maybe even blurring into the next one a little bit. And then we will continue with um, what's his face? Deputy Dwight Van Horn. We go into a couple law enforcement and then back to this guy like well later, a week later. So it's kind of annoying that we had to break him up, but that is what it is, unfortunately. So there you have it. I apologize again for taking the break last week. I had a migraine 4 straight days, kind of leading into five. Like the migraine was gone after five, but I was still feeling what I have now learned is a migraine hangover. I didn't know that that was a thing, but that is a thing. And I get it. I get a migraine hangover all the time, every time I get a migraine. So, and it was just a really bad one because my migraine was so bad. So I think that is what was happening with me. So I apologize for that, but I am feeling better. And now that I'm feeling better, I'm trying to get ahead and catch up and get a few pre-recordings done so that I can, if things like that happen again, it won't be such a big deal, but we'll see. All right, so thank you guys for watching. Take care. Make sure you hit the like button on your way out, and I'll see you guys in the next one. Bye now.